facts. Is that correct?
Yes, Your Honor.
All right. Do you understand that the Commonwealth, in this case, is required to prove each and every element of the case against you beyond a reasonable doubt? Do you understand that?
Yes, Your Honor.
Before testimony even started Tuesday, the defense did something that tells you more about their strategy than a full day of cross-examination would. They agreed not to fight the evidence at all. I'm not here to guess what happened before a jury does. I'm here to make sure you actually understand what's known so far. Here's the term of the day: stipulation. In plain language, it means both sides agree a fact is true, so nobody has to prove it in court. Tuesday, defense attorney Kevin Reddington stipulated to the chain of custody evidence: the DNA, blood, fluids, and the exercise bands used in the killings. On the record, he was direct about why. Skipping that testimony saves days that would otherwise be spent proving evidence handling piece by piece. Now, here's why that single decision is worth an entire segment instead of a passing mention. A defense team doesn't hand the prosecution an easy win unless fighting it would cost them more than it's worth. And in this case, fighting the physical evidence would cost them everything that actually matters to their argument. Because Reddington has already said publicly that Clancy doesn't dispute killing her children. Contesting DNA and blood evidence for a killing nobody's denying happened would just waste the jury's patience on a fight that was never winnable and was never the point. Look at what that leaves on the table. Every hour not spent litigating physical evidence is an hour that gets redirected toward the only argument the defense actually needs to win: whether Clancy meets Massachusetts' legal threshold for lacking criminal responsibility. The stipulation isn't a concession, it's a resource decision, clearing the board of fights they don't need, so the jury's attention stays fixed on the one they do. Before we get to Tuesday's forensic testimony, one piece from Monday connects directly to this pattern and shouldn't be skipped. Portions of Lindsay Clancy's personal diary were read in court, describing her state of mind around her infant son's sleep struggles in the months before the killings. We're not going to read the diary to you directly. Paraphrasing is how we handle every piece of testimony on this channel, and this is exactly the kind of material where that rule matters most. What's worth noticing is less what the diary said, and more the fact that it entered the record at all this early. Personal writing like this is exactly the kind of material a defense team wants in front of a jury before expert psychiatric testimony begins. It gives jurors a first-person account of distress to hold in mind before anyone puts a clinical label on it. Whether the defense or prosecution introduced it changes what it's meant to do. A defense-introduced diary humanizes distress ahead of the psychosis argument. A prosecution-introduced diary would be used to show she was distressed but still coherent enough to write clearly. Either way, it's not neutral. Testimony like this rarely enters a trial without a specific job to do. To be fair to both sides, we're working from limited excerpts reported by news coverage, not the full diary or full context of how it was used in court. That matters. A single quoted line can read very differently in isolation than it does surrounded by the rest of the testimony around it. With the chain of custody fight stipulated away, Tuesday's testimony from state police and forensic scientists moved efficiently, exactly as the stipulation was designed to allow. We're staying at the level the court record supports here, not the clinical specifics. What matters for the case is that this testimony completes the factual record the prosecution needs, with almost no resistance from the defense table. Put this next to last Monday's medical testimony, and the site visit before it, and the shape of this trial keeps confirming itself. The prosecution is building an uncontested factual record as efficiently as possible, and the defense is letting them. Because every day saved on facts nobody disputes is a day earned for the argument that actually decides this case. With the factual record now largely uncontested, expect the trial to move quickly toward the part both sides have been building toward from day one. Dueling psychiatric experts testifying directly on whether Clancy meets the McColl standard. That's where this case will actually be decided. Everything so far has been the setup. To be clear, nothing about guilt, innocence, or Clancy's mental state has been established as fact by this court. This is analysis of trial strategy based on public reporting, not a prediction of the verdict. Lindsay Clancy has not been convicted of anything. We'll keep treating this as the live, contestant trial it is. We'll be back with the next update as soon as the expert testimony actually starts. We'll keep following this the same way we always do. Carefully, and only with what's actually been proven.